Hello, everyone. Thank you for joining Ed and I for another update on the NAR settlement procedures that we've been going through for quite some time now. Obviously, as we've been relaying to you guys in meetings with brokerages, meetings with at our local associations, there's a lot of moving pieces and things are changing on a regular basis. We do feel comfortable that we do have some additional new benchmarks and solid ground to stand on to give you guys some information about where things are going. We have some dates to be sharing with you and some additional pieces of information. We are basically going to be putting a new presentation up on the website very shortly that will go through the full presentation. But I think for those of you guys who've been aware of what it is that we're doing, you know that we're adding in a concession field. We're having to remove comp out of the multiple listing service and some of the new forms and everything that are coming about. So basically, Ed, do you want to talk about some of the dates that we are certain of and have some possibilities of publishing within the CRMLS system
Yeah,
as of today?
exactly. Yeah, definitely, Art. Some good news is that the court in the cases have actually preliminarily approved the settlement. So the plaintiffs filed some paperwork telling the court, hey, here's our formal settlement agreement. And the court very quickly approved that as a preliminary nature. And that then triggered a bunch of dates. So now we have the actual dates in the settlement agreement that matter. And the most important one right now is August 13th. That's the time frame that we at CRMLS are going to be removing the compensation field out of the MLS. So the rules are going to be required to be in place and implemented as an MLS by, I think it's August 16th, Art, but that happens to be a Monday. And as a good MLS, we never make changes, on the Friday before a Monday with all of those kind of problems. So we're available to help support any change we make. So the change we're going to make is on August 13th to comply with the timeframes that are required in the settlement agreement. I think the other important date, Art, that we've been talking about, we've really been talking about this at CRMLS since October, right? And that is rolling out this concession field in price, right? A concession in price field on an active listing. It's something that we've seen you guys utilize with regard to closed listings. 40% of the CRMLS closed listings in 2023 had a concession in it. And so we want to bring this opportunity to you to market with that. And we're going to be rolling that out on May 29th.
Okay. Give me an idea. Obviously, August 13th, comp is out of the MLS. What other changes occurred during that time frame?
So the other changes that are going to happen when we get to August 13th is also going to be the NAR policy changes. So one thing that happened, Art, last week, as you know, we were at NAR up in Washington, D.C., and they finally published the changes to the NAR multiple listing service policies. And that's the document that we as an NAR MLS use to then take those policies and we convert those into rules. And so we're doing that right now, and we will be presenting those proposed rules to our board of directors at our May 20th meeting. And the rules are going to really mirror the things we've been talking about in the settlement agreement. The things that are going to impact our membership the most is going to be the requirement that you sign a written agreement prior to showing or doing a tour of a property. And the rules will have a lot more detail about what is a showing or a tour, the timing involved, and the necessary elements and features of what that agreement is going to have to contain to comply with the rules. And we at the MLS will then be creating compliance measures and enforcement parameters, including some fining structures around a violation of those rules of having a written agreement before you tour property. That's probably the biggest one that's going to impact the most people kind of right away. Then we're going to be also adding some rules about not putting into the multiple listing service anything related to sharing commissions from the listing broker to the buyer's agents or buyer broker. Right? We already know that we're going to take away the formal field that we currently have, right, of offer of compensation. That's going to be gone. So you can't use that. But guess what? You can't use any other field either, right? So Art, we're not going to let people put it into comments. We're not going to let you put it into showing instructions. We're not going to let you to put an offer of compensation maybe at the bottom of some document that you attach as a supplement, right? So no matter what words you put behind the what if, I'm going to tell you no if it relates to offering compensation somehow inside the multiple listing service.
So obviously, we're going to the board of directors on May 20th with a lot of these changes. Some of the questions that I know you and I are receiving on a regular basis as we go out and do these presentations, are centered around, what's the big deal on the showing side, and what's the big deal on, the buyer broker representation agreement. Obviously those were negotiated parts of the settlement. Also, why are you so focused on that, Art? I think it's important for people to understand that in signing along with this settlement, in order to remain safe on the side of the plaintiff's attorneys in going forward with a settlement, we've got to make sure that our brokers and agents are following these rules as they've changed. So, obviously we've got some work to do. The board of directors has got some decisions to make in regards to what those compliance efforts look like, but there are quite a bit of still moving pieces that I want you guys to pay attention. I'm saying this over and over and over again in presentations, but this will be a summer of education for everybody who practices real estate. There is
Can I say
nobody
something
who
on
is,
that?
yeah, there's nobody that has got all of it down at this point. There are so many different things that are changing that you need to stay on top of it.
So Art, I wanted to highlight something you said is super important, right? You made a reference to this written agreement, and the reason we're going to have compliance about it is it's to protect you guys, right? So realize the way the settlement agreement is organized is we as the MLS have to do these practice changes so that we get a release from the national class, and that's how we're going to be protected against other people filing lawsuits, right? We'll be able to show, hey, we have been released because we've engaged in these practice changes. I think one of the things people are missing, Art, is that the section in the settlement agreement about the written agreement before you tour a property is not just to us as an MLS. Any brokerage firm that is receiving a release under this agreement also is obligated to do that. So what does that mean? If you try to find a way to not do it, don't sign it, I'm just not going to pay attention to it and see if the MLS catches me, you don't get the release either, which means you can get sued again for these exact same matters from other plaintiffs because the release won't apply to you if you don't engage in the practice changes. So, Art, it's more than just the MLS with regard to these written agreements. That obligation to be protected is also on the brokerage firm themselves.
So I'm going to throw you a couple of curveballs, Ed, that
Sure.
we haven't discussed, but
Okay.
ones that I get regularly speaking about this. Obviously, one of the things we didn't talk about was the CAR forms, and I would highly recommend as we go along, getting training on the forms, getting training on the new listing agreement, the new changes to the RPA. CAR's meetings were last week. They approved changes to 65 additions and changes to forms. So there are some pretty huge and heavy lifts from an education standpoint that you guys need to be involved in. But there is going to be that time frame that occurs after the new forms come out. And obviously, we're not removing the offer of compensation out of the MLS until August 13th. There is probably going to be that time frame where you guys are going to have to get your arms around these changes at the conjunction of the forms coming out without the changes in the multiple listing service. So one of the things that we're going to go through is a process of walking you through the form as we get a final releasable version of that, and walk you guys through how that interacts with talking with your buyers, talking with your sellers, and how it interacts with the MLS rules and how to input it into the multiple listing service. So education, education, education. Pay attention to us as much as you possibly can, and we're going to do everything we possibly can to give you all the information that you need. So obviously, Ed, I don't know if you have anything to add on top of that, but there are going to be some of those questionable times, and our call center, our training department, are staying on top of the the concession fields that are coming out in June, the forms that are coming out in June. And there's just a lot of, it's going to be a lot of questions, we know, and our call center is probably going to field a lot of that, the brunt of a lot of that, but we want to make sure that the brokerage community has an understanding as well.
Yeah, I think by rolling this, some of these changes out now, both from CAR and us, it's going to give you guys the opportunity to kind of do it the new way if you want before we get to August, right? So right now, today, you can put 0 in as a comp, right? So if you want to embrace the more consumer-centric model of how you charge and how that functions, you can do that today, and work that process. And then when the new forms come out, that will even give you more opportunities to utilize some of these other options in mid-June when those forms go live, and the MLS will be ready when those forms go live to accommodate that. So one of the things in the forms art specifically that I've seen is the new form has a section on concessions, right? So you'll have this option to talk to your seller about concessions. What do concessions mean? And be able to get permission from the seller in the listing agreement to put a specific number in a concession, or the checkbox that we're designing that's a yes, no, that's going to be able to put into an active listing the phrase, a seller may consider a buyer concession if an offer. So that way your seller doesn't have to make any commitment to any number. And the way that the new CAR form is organized, they're separating out a little bit the how much money goes to the listing agent versus the buyer's agent, right? So you don't have to share commissions using the CAR form. You can choose not to by not filling out anything going to the buyer's agent as a sharing level and handling it in some other manner. And so that's a good option too. And we will be ready in the MLS to accommodate anyone who uses the new form in that way, and that we will have the appropriate fields that are ready for you to use.
Yeah, most definitely. And, you know, it's going to be, I think agents are going to have some level of confusion after getting their hands on the forms and knowing the changes that we've talked about. So we're going to do everything we possibly can to walk you guys through the process. And I'll probably even go through zip forms and fill out a form for you guys and show you, you know, how it all would interact with the multiple listing service. So Ed, any final words for everybody before we wrap up today?
I think just stay calm, right? These are some changes. I think the changes are good. I think the changes will really help those really high value agents perform really well. Stay in contact with your broker, right? There's a lot of broker decisions that need to be made with regard to how you want to operate your brokerage company. Do you want to continue to share commissions off the MLS? And that has some risk potentially to it that you should maybe talk to your lawyer about? Or do you want to embrace the new consumer-centric model, which the forms and the MLS are enhancing that opportunity? These are choices brokers are going to have to make moving forward, right? So as agents, make sure you're listening to your broker, making sure you're getting the training that your broker wants you to have. And brokers, make sure you're keeping your ears to the ground on what we're giving you as far as dates and opportunities to learn and the options that are available to you as a broker in various ways that you can manage the way you want to perform your business model, you know, out there. There's just a lot more choices you get now.
Yeah, so thank you everyone for attending. If I could do anything, I probably would like to shake all of my 100,000 members by the shoulders and say, pay attention, because these are some big changes. And we want to make sure that you are not walking into a closing situation where you on the buy side have not negotiated a fee for your services and are walking away with nothing. So these are important things, very important things for you guys to pay attention to. And we're going to do everything we can to keep you guys educated. Stay tuned. We'll be back very shortly with some new videos and new material to walk you guys through this process. Thank you very much.